up in northern Arizona. So excited to be on here with all of you because this is something that's very timely and going on right now. As if you are not aware, the FTC just a few weeks ago banned non competes, which non competes were a big way that employers were using to make sure that their confidential information did not end up in their competitors' hands. And so this ban making them illegal now for a majority of employees in the United States, now brings up some questions on, well, how do we protect our confidential information? How do we keep our competitive edge? How do we make sure that the employee is not taking our information and giving it to the other side in light of this? And that's what we're going to talk about today. So, very timely and exciting time. Now, we're going to look at this through the employee employer lens. And as we do that, we're going to kind of see some different phases. And so I'll walk you through what those are. But do know we obviously cannot get to everything today. There's many more opportunities than what we have here, but we are going to get into the most obvious, easiest, and most cost effective way to do that. And we're going to show you two levels of that today. Now, who am I? My name is Acacia Thornton. I'm the CEO legal coach, longtime licensed attorney, even longer business consultant, and award winning sales rep. I believe that all business owners of all sizes, even before you make your first dollar, you have the right to protect your ideas and make a dream business from them. And so this really speaks to that today. But first and foremost, why did the FTC ban non competes? This is a really big thing here. And I have to admit, despite my mission in life to support small businesses, I love what the FTC did here. See, a non compete prohibits the employee from going to work for a competitor. And some companies would just give an industry saying, hey, you can't work with anybody that works in this industry that we are in. Some employers would give a list like, hey, here's our top 10 or 20 competitors. You can't go to these people or these companies. And other times they would just say you can't do anything that's related to your job. But here's the thing, where else is the employee supposed to go? It ended up locking the employee themselves in a job, in a career with an employer, whether or not they wanted to be there after a certain amount of time. They were being denied opportunities. A great example is one of the Fortune 500s I worked for. I won an award with them. It was amazing. I loved working there. It was absolutely wonderful. But then, for many personal reasons, I ended up moving to a different state. And I wanted to change the type of role that I had. But being in this new state, there were very limited number of employers available. And guess what? One of them that I was qualified to work for was a direct competitor. And it didn't matter if I went to work for this direct competitor as an attorney, as a consultant, or as a sales rep. I was prohibited from moving on with my career. And I have had many friends and family members where this has happened to too. Sometimes we just need to change whom we're working for because it's the next right step in our lives. For any reason, family, friends, career, there's many reasons. And that's why the FTC started banning the non-competes, is that it was putting a lot of restrictions on the employee's ability to make life decisions for themselves. They would sometimes have to take less pay, go to an industry or a job they didn't love for a year or two, waiting for that non compete to wear out. But employers were saying, hey, we need these non competes to protect the information. And this is where it becomes really, really awesome in what the FTC did, because the FTC, in making this ban, is separating the decisions of where the employee goes from where your information goes. Your information and the employee are not one and the same. Your employee may go where they'd like. Does not mean they have the right to take your information with them. And this is where we're going to kind of get into these 2 points here. A non compete, what the FTC banned was non competes versus non disclosure. Non competes were about where the employee could or could not go for employment. A non disclosure is where anybody, in this case, the employee, may or may not be able to share your information. We're now separating these two concepts. And we're going to get into today that the non disclosure option is not the only way, there's ways to enhance beyond it. But there's also this further idea of knowledge and awareness of your information and of your intellectual property is different than the ownership and the ability to make choices regarding it. So employees might have awareness of your information, they might know your information, but that does not mean they have the right to make the decisions. And that definitely doesn't mean they have the right to own it. So having these differentiators now comes to the forefront in what the FTC is doing with the ban on non competes. So now let's look at this action headed your way in today's call. We're going to go over just kind of quickly, briefly, 20 minutes or so, looking at some things you can do during their employment, after their employment, and even what you can do about the new employer. There is also a difference between your employee and their new employer. And then of course, as always, we'll have an open Q&A for you and the opportunity to give you a nice freebie that's going to help set you up for success starting today. So, getting into the start of employment. If you are not already having terms of non disclosure, that could be an NDA, which is non disclosure agreement, or it could be terms of confidentiality in their employment documents with you. Either way, it is very important to have these terms, and they would probably exist in your documents already outside of your non competes because you don't want the employee, even when they're in your employment, to share your information with anybody else. Because they could go to an industry event like a conference. They might have friends that work at other places. They might want to use your information to make their own company or something. Well, guess what? They don't get to do that even during the term of their employment. So it's great to set that up from day one during the employment opportunity. And then explain practical examples to your employee. Here's the thing, not everybody knows what an NDA is, they don't know what that means. I was sitting at a co work space in Sao Paulo, Brazil. Sao Paulo, Brazil. And this girl, young employee, I'm going to guess if she went to college, she was just out of college, and she's having a phone conversation with her manager. I hear everything the manager is saying. I hear everything she is saying. She wasn't even wearing headphones, nor was she in a phone booth or anything, sitting right next to me, having this wide open call. And on this call, I heard that they just hired somebody who came from one of their competitors and that they were now having this business plan to as their way to now compete in the market. I learned all of this by sitting next to somebody in a co-work space. After the call, I asked the employee, I was like, hey, can I ask you a question? Do you have like a non-disclosure agreement or any confidentiality terms you signed when you started with your employer? And I had to explain what that was to her, that you have to keep their information safe. And she goes, yeah, I think so. I was like, the call you just did. And I demonstrated to her how I heard everything. And she goes, oh my God, you don't know who I am. You don't know if I work for your competitors. You don't know if I know the person you just hired. Employees don't always understand the practicalities of what it is to keep information confidential. Sometimes they think if I haven't literally uploaded it from the servers and emailed it to myself or emailed it to my friends or posted it on the internet, therefore I'm not disclosing, which is not the case. So, whatever your company is, whatever types of information your employee is going to have access to, and the areas they might be interacting around others, it is helpful to just walk them through ways. And sometimes this happens with corporate trainings. Some companies have pre established corporate trainings, but if you don't, that is okay. Just walking them through this, helping them understand why it's important to the company to do these things and what that actually means for them and their role. Because once they understand this, they feel a sense of responsibility and belonging to doing the employment role correctly. And they're likely to jump onto that. Also, set data use policies and make sure those are clear from the beginning. How can your information be used or not used? And set data access limitations. Don't throw everything for your company onto a shared drive and have all employees have access to that. Make sure they know what they're allowed to access and when, and setting up those boundaries. Because it doesn't just start with where the information goes after their employment, like the non compete situation with the FTC. The truth is, your competitors can get a hold of your information at any point in time during their employment, even while they're still employed happily and supporting your company. Things might happen by accident or just from a lack of awareness. As they continue their employment with you, it is important to make sure that as things progress, maybe they're getting promoted and now they're going to be a manager and leader of a team. Now they're going to have more information at their hands, more personal information about the team, but also greater insight into the company's higher level goals. So, making sure that during the term of employment, you're setting the right example, the right boundaries, and updating terms of confidentiality if and where appropriate. Maybe in the beginning, the NDA they signed was just about doing cashier stuff. But now that they're going to be a manager and have access to the records and the books and the bookkeeping, it might be time to update what is included in the definition of confidential information so that the scope and boundary for both parties is properly defined. And then continuing with that data security, another great one is to mark items as confidential. How is an employee always supposed to know or remember? All of us forget that conversation we had a few months ago or years ago. They've been working with you for a while. It is always good practice to mark things as confidential. I do this whenever I'm making new product information that hasn't been released to the public, but I need to share with my team. Always mark at the top, confidential until disclosed to the public. Those types of things can be really helpful. Same with the emails that you can mark on some employment uh, business email programs, internal use only and external use only. Having these differentiators helps indicate even to your technology what is and is not allowed outside of the company. And using your technology to help support those boundaries is great. Also indicate what is intellectual property. Mark the C if you have a copyright in something, mark something as a patent. But the most important intellectual property to mark and indicate is trade secrets because trade secrets don't get filed anywhere. They don't get filed with the USPTO, the US Patent Trademark Office. They don't get those filings the way copyrights, trademarks, and patents do, which means there's not really a record available with a third party. Because the whole point of a trade secret is that it was never disclosed to a third party. So making sure that your employee knows when they are accessing or available to a trade secret. Because without that, you might accidentally lose the trade secret, which is not good because that's your intellectual property. But also, you're putting your employees on proper notice and friendly reminders along the way. It's just good practice to always have your employees assume everything is confidential at a minimum. Nothing is allowed outside of the company. And having these proper boundaries, policies, and reminders along the way is how you're going to be able to enforce that. Because when you have these policies and you have these procedures in place, it not only reminds the employee, but should anything go wrong, you have something that you can demonstrate to the courts or your arbitrators that this was the ongoing practice. So there shouldn't have been any confusion and that you have taken the steps necessary to protect and retain your rights. Now let's move on to when an employee departs, because this is when things shift. Now you have less control over where the information goes. You have less control over how it gets used and how it gets shared because this person is no longer in your employment. And they now might be going off to start their own company, which may or may not compete with yours, but also it might go to your competitor. So, first is when an employee departs your employment, remind them of their NDA. Remind them there are ongoing obligations that continue after their employment. It is common sense to think that when we're done with an employer, our obligations to them end. That's that. We're done. Wash our hands. Not the case if you have the correct NDA in place with your employee, whether at the start of their employment or when you updated it along the way. Now you're going to just kindly remind them, either through a letter in the mail, or if you have an exit interview, you just have them sign off. They do remember they have signed that NDA, and the NDA does have an active time frame that survives and goes post their termination of employment with you. And this is where it starts to overlap with where non competes used to be. Non competes used to be for a year or two after the employment. Well, now you can have your NDA extend beyond that. So while the employee is free to go, they do not have the rights to use or share your information for themselves or with any third party in that time frame either. So the NDA does that. Use an exit checklist. If you're not familiar with my Boss from the Beach program, it really starts to get into a lot of these breakdowns because that whole program is about protecting your information in the employment context. But if you don't have an exit checklist, I suggest you make one as you start to give your employees access to things like a security badge. If they have logins to things, do they have a laptop from your company? Do they have access to your cloud? Do they have a personal device? Sometimes companies are great at keeping a company cell phone versus the employee's personal cell phone. Well, maybe the employees intermingle these things a little bit. So have an exit checklist going through all of the things the employee may have had or been granted during their employment, making sure that one, you get them back, and two, that the employee has a friendly reminder it's no longer theirs to be used outside of the employment context. Deactivate all logins. These logins are those to your internal places, like if you have an intranet, your shared drive, your company email, and things like that. But then also third party. If you maybe have like I know for a lot of times, like my legal research platforms, those weren't owned and operated by my company. They would hire outside companies. And so we would have access to those via the login. The login and my access was for that employer, for that client, for the purposes of supporting that client. It is not to be used for my personal use. So it is important that they reach out when I leave to those third party providers saying, hey, we need to update the employee access list. These one or two employees are no longer with us, or here's the people who have replaced them. Can we swap this person out for that person? Those kind of things. And making sure that you have in your calendar, in your events, and so on to remind yourself to do these. These things are easily lost because they don't feel like revenue generating activities. And it can feel great that once the employee is out, it's done, you wash your hands. But the truth is, this is when the opportunity for the greatest data breaches occur, even though majority of data breaches are not intentional and they're not malicious. They just happen from accidents, from oversights, or because we love sharing what we know with the people we trust. Your employee may do the same unknowingly. So if you want to protect your information, take it upon yourself to take these actions in this point in time when you have the opportunity to do so. Because when you set these boundaries again and you reinforce them with your actions and your policies, but also remind the departing employee you set better boundaries and a code of conduct. You show this ongoing behavior so that if something gets out there and there's any question of whether or not it was meant to be confidential or protected, you can show how you have had ongoing behavior that says, this is how we treat this information. Yes, it was protected. It wasn't just given away without anything and praying to God that it didn't get shared. We acted as if it was to be protected, and therefore it should remain that way. So that ends the part regarding the employee. Let's start now looking at the other half of what a non compete did. The non compete prevented the employee from going to a competitor, but it also prevented the competitor from getting access to your information too close in time. When an employee leaves and they give 1 or 2 week notice, well, guess what? The information they're leaving with may only be a week or two old at most, especially if they're still getting access to information during those 1 or 2 week notice periods. And then on Monday, they go start at the new employer. Not much time there, right? So now let's look at the main way you can keep the new employer from having your information. Now, a challenge with the new employer is they don't have a contract with you. You have no contractual rights to enforce against them. You have the NDA with the employee, So if the employee breaches the NDA, well, they're breaching a contract. So how do we keep the new employer accountable? There's a few different types of ways. And again, there's a big list of them in the Boston the Beach, but the main primary way that is going to really, really emphasize why NDAs are the new way to keep your information safe in the ban of non-competes is there is this thing called tortious interference. Tortious interference. Okay, what that is it's knowingly inducing or causing another party to breach an existing contract. So the existing contract is not with the new employer, but if they knowingly induce or cause somebody to break a contract that you have, well, guess what? Now that party can also be on the hook, not for breach of contract, but for tortious interference. So if we change out those few words there, we now have tortious interference is if the new employer knowingly induces or causes your former employee to breach the NDA. So this is how, if we set you up for success early on, you can not only have the NDA set with your employee, you can now hold the new employer accountable. Now, a key thing to note here is the new employer has to know. They have to know about that NDA, right? So what are you going to do? When the when the former employee is leaving to go to the new employer, if you have reason to believe that that new employer is taking the employee for the reason of access to your information, or that employee is going to have a very similar job with using that it'll almost be impossible for them to do that job without using your information, you're going to send a letter to the new employer. This is a cordial, kind letter. Nobody's broken the law. Nobody's done anything harmful. They have the right to hire whomever the best um, applicant was, right? If that was your employee, they have the right to do that, but they don't have the right to take your information. So you're going to send a letter, a cordial letter saying, hey, just want to let you know that you have hired so and so. That person is a former employee of ours. They are under the terms of an NDA regarding certain information. If you do have any questions about it, let us know and like and go in peace kind of a thing. It's just an FYI. And when you send that letter in a way that is legally enforceable, usually by signed certified mail, something with a signature, you want to make sure you can guarantee it was in fact delivered and received on a particular date by a particular person. You now can demonstrate that the new employer knows that there is an active contract protecting that information. And that now gives you an opportunity to hold the new employer accountable should they cause, induce, or even if the employee starts to share with them, they have a responsibility to be like, hold up, we need to make sure that what you're sharing with us, we're allowed to have access to. So that is the new cool way to do it. While there are many other causes of actions you might have against the new employer or the former employee, tortious interference is going to be your key one against the employer, but that does require that you have an active NDA, an active contract protecting your confidential information that continues to be ongoing after the employee leaves your employment. So, going back to those main key things there, having those terms from the beginning, reinforcing that behavior and the value of that information during the term of their employment, but also as they leave with the exit interview and your behavior then, plus a letter to the new employer is going to set you up for success in a way that honestly is stronger than you would have had with a non-compete, because a non-compete you never would have been able to enforce anything against the new employer other than inducing the employee to leave you, which is not as harmful as if they take your information. So to protect you, today's freebie is a free employee NDA. Right? I'm going to set you up for success. I always promise to do so. So you can have that NDA to have your employee sign from day one, in the middle of the employment, or as they leave, whenever is appropriate. This is the NDA you're going to use. You'll find that at CEOLegalcoach.com/free employee NDA. and you'll have a customization guide. I'll have a video reading it to you, everything you need for success to get you that protection right here, right now, today. So let's find the chat, and I'm going to start answering your questions right here on the spot. You can put them into the chat, whatever platform you're in. I will get them in real time, and I already see some coming in. Oh, excuse me. Oh, that doesn't even have water in it. Thank God I have two. Coffee. I love to say coffee's like water for the soul, right? I love it. Okay. Questions. What do we have? How does the FTC's ban impact your existing agreements? Okay. If you already have agreements in place, two things. If any of your agreements included a non-compete, under the FTC's new ruling, you have the obligation to inform your employees that it was there and you're not going to enforce it. You have that obligation. So even if you like just say we're not going to enforce it, but don't actively tell your employees this, you're actually in violation of the FTC's new rule. So step one is if you have a non-compete, just non-competes. It doesn't matter if it's a non-compete as a standalone document or if it's clause in an existing document. The existence anywhere in the employee-employer relationship triggers this. You now need to tell the employee it's there and that you're no longer allowed to enforce it so that the employee knows this. And then the second part is to check the validity of the rest of the document. This is something that the FTC didn't speak to in their ruling. And it's a big one because it now means that the rest of your document is 50-50, not even enforceable. So let's say you had an NDA in place, and it could be any contract. I'm just going to use an NDA as an example. But let's say you had an NDA and the non-compete part of it, the part that is now banned, was just a paragraph within it. Just a paragraph. What happens to the other 99% of your NDA? You need to check for a severability clause. This comes down to the quality of the template you used. If you used a cheap online template, particularly a free one, you likely don't have a severability clause in there. And what a severability clause is or says is that, hey, in the event any part of this document becomes invalid, unenforceable, or is no longer allowed under active law, that part will be removed, but the rest of the document will remain full and force effective. So severability is almost always what it's called. You can just like Control F in your document, use your template if you want. See if there's this word called severability. If there is, and that clause is in there, you do not need to worry. The rest of your document remains in full force and effect. If that is not in the document that included your non-compete clause or any other terms that you want to keep active, you now need to get a new one signed. The rest of your document is no longer enforceable because under the law in most states, once part of it is deemed illegal, the rest of it is deemed to be that way as well. So it does come down to each state. Not every state is exactly that way, but it is a good like rule that if you have one, just make sure it's in place because you don't want to find out after the fact that, oh, the court said no, the whole thing's out the window. So that's the way the FTC's ban currently impacts your current any non-competes you have or any agreements that the non-compete was in. That's how that impacts that. Next question. Are there any exceptions to the FTC's rule? Yes, the FTC did say that you are allowed to continue non-competes for high-level employees, usually directors or higher. Now, it doesn't quite, no, you can't just go around now and give everybody a title of director. The courts and the agencies have been very mindful of the way an employee's behavior, their job description, their role, the level of authority all impact. So a title is less important than the role the employee has. But if the employee has a role that it would be equivalent of a director or higher, particularly with that title under the FTC's new ruling, you are allowed to keep the non-compete in place. But here is what I would say. When you have that, it still needs to be narrow. Just because you're allowed to keep a non-compete at that level does not mean you get to just be like, okay, well, let's keep it for all possible competitors for 20 years. It's overkill. The courts are going to start to be more scrupulous about how detailed and refined it is. Because remember, the goal here is to not prohibit employees from making their decisions based on what is best for their lives and their careers. So if your non compete is overly inclusive, is broader in scope, time, industry, competitors, then it needs to be to genuinely protect the information this employee has access to. It can still be deemed invalid. The FTC's ruling does not guarantee it gets to stay there. Courts for a long time have been finding ways to nitpick at non competes already. In fact, many of them in some states aren't really enforceable as it is. So, under the FTC's ruling, still be mindful the courts are going to continue to scrutinize them very heavily. So, if you have one and it is for a higher level employee, do make sure to still very narrow in scope. But guess what? Even if it's not, just like today's thing, it's not the only way to protect your information. Employees who have higher level stuff like C suite, attorneys, partners, your board of directors, they have additional causes of action you can take if they violate things. Usually it's under fiduciary duty, right? I, as an attorney for my clients, I have a fiduciary duty to them. So even if I don't have an NDA or something else in place, I have these other ethical obligations based on my role that is tied to the employment level. So even if you don't have a non-compete or you find out your non-compete is unenforceable because it's overly broad, there might still be other claims that you could have against the employee if they decide to go out and share your information. But again, if you have an NDA in place, same rules apply to them too. So just because you might still be able to have a non-compete, you can also put that NDA in place and you have that protection that way too. Yep. Great question. Great question. Da, da, da. How do I communicate to my team? All right. We just talked about the FTC saying that you have to tell them and that you might need to now change things. What if I now need to have everybody sign an NDA? What do? One, show them the good side of why you're doing this, right? And why are you doing this? You want to do the right thing. And everybody loves to be part of doing the right thing. They're really excited to do things the right way for the right reason. And so letting them know, hey, this is no longer enforceable and legal, and we want to do things the right way. The right way is to do it this way. And then start to paint a picture about how their actions play into supporting and building the company. Having the company continue to thrive and be protected creates camaraderie, creates a reason for everyone to be on board. If the company is no longer protected, then everyone's employment is at risk. Everyone's futures, the career, the mission everyone came to support is no longer s- structurally sound, right? So letting them know we're doing the right thing for the right reasons. We're all in this together to do this and get them to share in that mission again. Get them to share and be part of the why and the how, and reminding them of their role in all of this creates that great opportunity in the future of success for everybody because their success is the company's success and the company's success is their success. So I think instead of coming at it with a you have to do this, this is how things now are, we have policies, creating the bigger picture and getting everybody on board with a value system and a mission and purpose is going to be the greater success for sure here. Yeah, that's how I would do it. Um, I'm going to what's the mm, oh, okay. How will the FTC's ban on the non-competes affect my ability to recruit and retain top talent? Yeah, it can feel like suddenly the floodgates are open and your competitors can now poach from you. Well, guess what? It's not poaching. It's an open market. you have the exact same opportunities as everybody else. And if you have a massive exodus from your company now, it let me take a step back for a second. I remember working for a company that came in and one of their other divisions, another division, and they were like, look, we need people with your talent and your experience in this division. If you want to move over to this division, we will give you a 10% raise. 10% raise. And for some people, they were going up to 14%, depending on the role. 14% raise to go over there. I didn't do it. My boss didn't do it. And why didn't we do it? We didn't do it because that job, that role description, even though it was for the same employer, it was with a different product base. It was with a different client base. It was with a different team that very successful, but not where I was going to be happy, not where I was going to be successful. I was willing, and so was my boss, to continue our ongoing salaries and let go of the opportunity to make more money because we were happy where we were. We believed in the job that we were doing and the people we did it with and for. That has value too. I think it was Amazon, I could be wrong on that, who offered their employees $2,000 to leave because they understood if you're willing to leave over $2,000, this isn't where your future was. This isn't where you feel connected to building something long term. So if your employees are so eager to leave, it might be this was no longer the right place for them. Doesn't mean you did anything wrong at all. It might just be family, friends, lifestyle for them that now changed. But it also gives you the opportunity to now attract the people that are best for you, that are going to build your company's mission long term. If you're going to be happy to support your products, your clients, your vendors, everybody that is tangential to making your company a success internally and externally. Having the right people in place, you now get the opportunity to attract the right people for that. Maybe when you were employing, you got what was left over in the industry because the real people who wanted to come to you couldn't because they had non-competes. So do remember that just as your employer, your your competitors have the opportunity to take your employees, you now have the opportunity to find the right best employees for your future of success as well. All right, guys, we're at time. If there are any other questions, go ahead and put them into the comments. I will get to them, or you can always reach me at my website, CEOLegalcoach.com. I hope you have an amazing